What role is social media playing in Latin America, and has it had a positive effect on brands and brand management?
Well, the role of social media in Latin America is similar to the one that has been seen or is being seen here in the US. Social media is being adapted by brand owners, and of course this brings also some challenges because the Latin American legal systems are very different in many features, many aspects to the US trademark system. For instance, all Latin American systems are first to file. They provide very limited rights based on use. So when you are thinking to use your brands on social media, you probably, of course, have to do it in a very quick way. Most of the time, it's not possible to complete registrations. So if you are using a new trademark in your social media efforts, you should be very careful about the legal risk that you might be facing in Latin America. Because as I said, those are first to file countries. The backlog to complete registration is growing because we are seeing more and more trademarks filed in Latin America. The number is growing, even much more in a higher numbers than in the US. So, for instance, Brazil has seen a 150% increase in the number of trademarks filed, and this is because the most economies in Latin America have been growing at a very fast speed compared to the speed of growth in the US, Europe, or other developed countries like Japan, for instance. So social media, I think, is going to be a more important tool as it happened here in the US. But users of brands in social media should be careful and should analyze the legal risks posed when they do these activities in Latin America.
How do brands or companies deal with differentiating real branded social media content and consumer or counterfeit chatter?
Yeah, brand owners have very many difficulties finding or policing permitted uses of the brands also in social media in Latin America from those allowed uses. And this basically is due to the fact that the social media is so quick, so fast. The content that is being created is growing and growing. The number of trademarks filed in Latin America is growing, but I think is not really reflecting the amount of activities, the brand activities that we are seeing online. And there are some particularities in Latin America, like if you don't have your trademark registered in a particular country and you are using it online and you are saying that the trademark is registered in that particular country when it's not registered, that could be a problem from a legal point of view. So that's one of the aspects that should be kept in mind when using brands online. And once trademark owners have their brands online and they start interacting with the public, with consumers, then the limitations that brand owners have to control the use that the consumers or third parties are making of their brands depends country by country. For instance, of course, consumers, they can pose negative opinions as far as they are real and objective, but those are areas regulated by civil law in most Latin American countries. Let's remember that these are civil law jurisdictions. Latin America doesn't follow precedent, so legal cases as it stands here in the US, which is a common law system. So here in the US, legal precedent, one decision has control over other decisions issued afterwards. It doesn't happen like that in Latin America. Very few countries follow what is called the stare decisis principle, basically meaning that legal precedents are binding for the courts. So it's an area where legal uncertainty is growing. So I think we lawyers in Latin America have many challenges, and I think we will need to be very creative. We'll need to discuss among us different possible solutions, and also we'll need to really be aware of how things are being dealt here in the US or in Europe, where the number of legal cases, legal decisions is much higher. In the US, you can see opinions by judges about use of brands in social media much more frequently than in Latin America. We also in Latin America don't have many provisions in our trademark laws or other laws dealing with some of these aspects. So I think there is a lot of space and room to propose changes, to discuss changes, and then to inform brand owners, consumers, and judges about the different interactions. The most important industries in Latin America where probably you can see the highest numbers of litigation, trademark litigation, are those industries where countries have a capability because they have the natural resources or because they have the history or some ties with a particular industry. So, for instance, beverages are a very well-developed industry in the Caribbean. You also have, for instance, coffee in Colombia and some other countries. You have tobacco in Central America. You have wine in Argentina or Chile, which is very popular now in the US or Europe. So there are some industries and some areas where Latin American companies have a competitive advantage, and where also, of course, foreign companies, they want to enter and they want to compete. So we are seeing more and more litigation there, or more activity, maybe not litigation, but the exchange of letters and some maybe coexistence agreements. But I would say the most litigious area is, of course, pharmaceutical. So pharmaceutical class 5 trademark cases are the most common ones seen. Also chemicals in class 3, although medical devices in class 10 or clothing in class 25 are also very conflicted areas or industries. So those trademark owners or lawyers advising their clients who want to enter products or to start to sell their products in those areas, they should be really aware, and they should at least conduct a screening. They should do a screening to check if the trademark that they want to use in Latin America has been already registered by a third party. Because if the trademark was registered by a third party, the company, once they start to import the products in the particular country in Latin America, they might have legal problems, basically. They might receive a cease and desist letter ordering to stop or requesting to stop the commercialization of the goods, and that, of course, can be solved. Usually it is solved amicably, but it will depend on the amount of money that the trademark owner wants to offer the holder of the trademark in that country, and also, of course, the particularities of each country, because sometimes if you are dealing with the Andean community, which is Colombia, Peru, Bolivia, and Ecuador, there are some particularities, because one trademark registered in one country in the Andean community might give you rights to oppose to trademark applications in other countries. And then we have the Washington Convention of 1929, which covers many countries in Latin America, including the US. And we are seeing now, I wouldn't say too many, but some litigation where the Washington Convention has been used. So overall, in those industries that are so important in Latin America, I think trademark owners and their advisors should be really aware and focus on how to conduct some basic search at least, and hopefully they have the resources and the time, a full trademark search to check any potential conflict, because the sooner you detect the legal potential conflict, the easier it is to solve the conflict, just doing a negotiation and finding an amicable solution. The World Cup is going to be held in Brazil next year, in 2014, and that is a huge event. It's watched worldwide by millions and billions of people everywhere. And so we are going to see ambush marketing and some other illegal activities, but also some activities which are unclear whether they are allowed or not by trademark owners and by third parties. And we should keep in mind that only Colombia and Mexico are members of the Madrid Protocol. Brazil is not a member of the Madrid Protocol. So those companies or individuals who are interested in protecting their brands in Brazil before the World Cup is being held next year, they should be, I think, already filing and protecting their trademarks, because they cannot use the Madrid Protocol. The backlog to receive a trademark registration in Brazil is at least 3 years, so they are already late, but still, at least counting with a trademark file in Brazil gives you some rights. It's better than nothing. And also remember that after the World Cup in 2014 is coming the Olympics in Brazil in 2016. So I think trademark owners should be really, really aware about these incoming events, which are going to be seen by billions of people in the whole world. And remember, Brazil is a first-to-file country. There are formalities to comply with, and there are some particularities from a legal point of view to keep in mind. And of course, the timing to complete registration is much longer than here in the US. The trademark offices of Brazil now are operating digital online, but this is recently. This started to happen a few years ago. So while here in the US or Europe, trademark offices have been operating online since at least the end of 1880s, in Latin America, most trademark offices have been operating online using digital docketing systems from the beginning of 95, more or less, and Mexico was one of the first countries. So these are very new trademark offices that we have in Latin America. They are doing the best job they can, but there are still many things where they need to catch up in terms of developing a better infrastructure, training examiners. They are receiving help and technical assistance from WIPO and some other offices from Europe and the US, but the work usually takes longer than in the US.